Thanks, Davina. So people can ask for a copy of their own personal data. This is called the right of access. It's commonly known as making a subject access request, or just a SAR. Your business must respond to this request within 1 calendar month. You must remember, people are able to ask a third party, like a lawyer or a partner, to make a request on their behalf. But where you receive these third-party requests, you must check they have the permission to do so. This could be evidenced by a signed letter giving consent, or perhaps a power of attorney. It could also be a parent or guardian exercising a child's right on their behalf. If this is the case, and the child is mature enough to understand their rights, you'll need to get their permission. If you believe they're not mature enough, you may carry on with a SAR, but you will need to ensure that any disclosure is still in the best interests of the child. Once you're happy you received a valid request, you'll need to make all reasonable searches for the data the person has asked to receive. Where you can, you should give a person the data they've asked for in a SAR, but there may be times when you don't need to provide all the information because an exemption applies. This may be the case where responding to a request means disclosing information about a third party. In these cases, you'll first need to think about whether the other person has consented to the disclosure. Where they haven't, or you think it would be too difficult or inappropriate to ask for their permission, you should consider whether you can share the data without the person's consent. As part of this, you'll need to look at factors like whether any confidentiality is owed and the type of information being asked for. So let's think about this in context. Let's say an employee asks for a copy of a complaint raised about them. If the person who made the complaint can be identified from it, even if their name is removed, you need to consider whether any confidentiality is owed to them. If you think there could be a negative impact on them which outweighs the right of access, you can withhold the data. Another common exemption you can withhold personal data under is the crime and taxation exemption. This could be where you've shared information about a suspected crime with the police. If the person accused of the crime makes a SAR, you wouldn't need to provide the information you hold about this if you thought that it would undermine your original purpose of detecting the crime. For example, this could be where you think it would lead the person to destroy the evidence. You can also refuse to comply with a request if it's manifestly unfounded or excessive. Now, this is a high bar to reach, but a request can be considered excessive if it's been repeated or overlaps with other recent requests. Similarly, you'd need to have a strong justification that a request is manifestly unfounded. This can be where you can demonstrate the person making the request has no real interest in getting their information and is only making the request to harass or cause expense to your business. You'll need to make a judgment call based on your specific situation. If you're going to refuse a request, you should ensure your reasoning is justified on a case-by-case basis and you've documented this.
Thanks, Chris. We'll now move on to answer your questions about SARs. So I've got a number of questions here that are coming in. So the first one, could I give this to Mariam? What's an appropriate level of redaction for a SAR?
Thanks, Davina. So I'm going to go in with this question based on the fact or based on the assumption that it's about redacting a third party or third party individual's information. So if you have a requester that makes a request for their own information and you have documents that include information about other individuals or other persons, you may have to redact that information. So this will really depend on the context. It will depend on the documents that you have and how embedded another person's information is with the requester's information. So if it's, for example, a spreadsheet with salaries, well, your HR department has a spreadsheet of salaries according to employee, it might be quite easy to just redact the top few employees' information and redact the bottom few employees' information. So that would be kind of appropriate redaction in that circumstance. On the other hand, if we think back on that witness statement example, so imagine that you have a person who's written a complaint or a witness statement about another person, and the person who's being complained about is making a request for information, it will be very difficult at times to separate the personal data of the person making the witness statement and the requester's personal information. So there you'll have to think about, if I redacted the name of the person giving the witness statement, will they still be identified by the person making the request? Can they be identified from the context, for example? And if that's the case, it may be that the whole document, because it relates to both individuals, would have to be withheld, because it relates obviously to the person that's giving that witness statement, especially if they've kind of provided that in confidence to your organisation.
Lovely, thank you, Mariam. Another question here, Chris, if you'd like to take this one. What's the ICO view on online SAR portals?
Sure. So similarly to as I've previously said, there's nothing stopping an individual using a third party or indeed a third party online portal to make a request. There are some things you need to consider. Just as I said before, you need to consider that whether you've received a valid request, whether that online portal has the proper authority to make that request on behalf of the individual, and you need to be able to verify the identity of the individual making the request. Now, with it being an online portal, there's various different ones that exist, but one of the key points is you need to be able to view the request without taking proactive steps. So if you're required to pay for a service or signing up for a service, that wouldn't be seen as receiving a valid request, and you wouldn't have to respond in that instance.
That's really helpful. Thank you, Chris. Actually, could I give you another question? I've got another one here that would be a good one for you. SARs are consistently used to gather information for a grievance and not for their official purpose. How can we best manage this, please?
Sure. So in the most case, a SAR, a subject access request, should be purpose blind. An individual can make it for many purposes. Granted, we did touch on manifestly excessive or manifestly unfounded earlier, but it's unlikely an employee gathering information for a grievance could be seen as manifestly unfounded. So it would be something you should be looking to disclose to them. Now, what you can certainly do, if it's often being used for this case, is try and work with the individual. They may ask for all the information you hold about them, but if you feel it's particular for a grievance, there's nothing stopping you from discussing it with the employee, asking what particular information they want. Perhaps they're looking for email conversations between a manager and HR. That's certainly something you can ask them to clarify. I will add, there's no need for them to clarify. They can still say they want all the information you hold of them. But as I said, there's nothing stopping you from making that, asking for that, if they can narrow that request down.
Lovely. Thank you, Chris. Another question here, which I could give to you, Sophie. In relation to an ex-employee DSAR, where they've asked for all emails which include their name, despite the context, and other people's data, in other words, talking to commercial partners, what information can we withhold?
Yeah, so the subject access request is for a copy of their own personal data. It doesn't give them the right to other information or other people's data. So where they're just a name and an email address, so say it's an email that's an office-wide email that's kind of about updating a general company policy, you wouldn't need to provide that in the same way that you wouldn't if it was all about the clients and the client's work, because it doesn't relate to them. Yes, their name may be in it, but it's not about them as an individual. So that information you wouldn't need to provide. So what you could do in those circumstances is have one redacted copy of the email and kind of say, we have found X number of emails where your name is mentioned, but the content isn't about you. They look like this. You can give them the redacted copy, and that's it. You wouldn't need to provide a redacted copy of every single email in the same way that just because they've asked for it, if it's not their personal data, you don't have to provide it.
Lovely, thanks for clarifying that, Sophie. Another question here, if you could take this one, Mariam. WhatsApp messages and MS Microsoft Teams chat, are these discoverable in a SAR when asked for all data held?
Yeah, so you'll have to think about whether WhatsApp messages and Microsoft Teams chats are used for a business purpose. So if they're part of your business's everyday activity and that's how you communicate with staff and you use it for your business in your business context, that will be part of the information that you need to look through or part of the documents really that you're looking through to respond to a subject access request. So I mentioned business context. When WhatsApp messages are used for personal use, and it's not part of your kind of business procedures, and it's, for example, 2 employees using WhatsApp personally, that might not fall within the scope of the subject access request because it's not in your business context. It's not being used in your business context. It's a personal use and falls outside of UK data protection law altogether, just because it's personal use or domestic use.
Lovely. That's really helpful. Thank you, Mariam. So another question, Chris, if you could take this one. If an individual, not employee, has made a SAR once a year or so for the past 3+ years, could this be considered as manifestly unfounded or excessive?
So, as I mentioned earlier, it's going to be a very much case-by-case scenario on this, and there's going to be a few different things that come into play here. So, firstly, it's unlikely to be seen as manifestly unfounded unless there's other information to show that they're using this to just disrupt your organisation, but potentially we could be looking at excessive. One of the points about being excessive is whether it overlaps with other requests or whether it largely repeats a previous request and not a sufficient time has passed between. So it very much depends on what your type of business is. Now, if you don't have a lot of contact with the individual and information hasn't really changed over a year period, it's unlikely that you would need to respond to this, and it could be excessive for that case. However, if it's a regular occurrence, maybe you speak to this individual or you have contact with this individual every couple of months, a lot of information may have changed since the last time they've made the request. So in a case like that, we might look to supply that new information, but then not supply the previous information because obviously you've already previously supplied that.
Okay, thank you, Chris. It's clear. Hopefully cleared that up. Another question here, if I can give this one to you, Sophie. Are parents always automatically assumed to have authority to make DSARs for children under 13? Oh, Sophie, I think you're on mute.
And we were doing so well.
It has to be
It had to be me. Yeah, so as I was attempting to say, parents are typically seen as having authority as long as there hasn't been some form of kind of court decision that's removed the parental responsibility from them. So in those circumstances, they wouldn't, but depending on your relationship with your child, the child itself is probably going to be aware of that. Now, even though they may be seen to have that authority, there is still the proviso that it still needs to be in the child's best interest to supply this information. So if you think giving the information to the parent is actually going to have a negative impact on the child, you can refuse the request, because it's important to remember that it's the child's information and it's the child's right to access their own information. The parents are just doing it on their behalf. The parents don't have a right under the right of access for their child's data. So it's still the child and it needs to be done in the child's best interest. But typically, parents are seen as having authority in the strictest sense of they can make the request, but you still need to look and check that it's in their best interest, in the child's best interest to provide this data.
Thank you, Sophie. And I've got on here, if I could give this to you, Chris. What is the view that you would have about sending entire documents versus just the personal data that it contains?
Sure, thanks, Davina. So I think the key point here is, what does the legislation state? Now, the legislation states they're entitled to make a copy, request a copy of their own personal data. There's certainly no entitlement to original documents or entire documents. So it's looking at it on what works best in a situation. Now, it may be a case that it's a simple email that clearly is about the individual and there's very little to redact in there. So that might be a case where we just provide the email with a small redaction in it. You may have another case, you may have an HR document that contains the names of all the staff and various other information about them, and a staff member's made a request. So in a situation like that, instead of going through and redacting the entire Excel spreadsheet, just leaving one line, you can certainly just copy and paste that line out into maybe a new spreadsheet or a Word document and provide it that way. So it's very much case by case basis, but there's no right or wrong answer in this.
That's really helpful. Thank you, Chris. And the question here, if I can give this one to you, Sophie. Does the 30-day response period start from the initial request or once the data subject has been verified? I think we get this kind of question a lot, don't we?
Yeah, we do. So where you've needed to ask for ID because you're not sure either who the requester is or that the requester is the right person for the information that you hold, and you've needed to go out to verify that they are that right person, the response time starts from when you receive the information that you need to make that determination. So if you've had to go out and ask for ID, it starts when that ID comes back. So you should be making sure that if you do have to clarify and verify who this person is, that you're asking right at the start of the request, that you don't kind of put it off or leave it towards the end. It should really be the first thing you do, so it doesn't impact too heavily on the person getting their response.
Lovely. Thank you, Sophie. And I think we've just got time to squeeze one more very quick question in. Mariam, if you could take this one. Do we need a DSAR policy and procedure written up?
So it's not mandatory, but it is good practice just to have that formal policy in place and a procedure written up, because it does save some time, and it does make sure that your staff is aware of what to do if they receive in their personal inbox or their work inbox a data subject access request. So you want to avoid the situation where a new employee is not aware of what it is and they wait around with that email in their inbox for 25 days and you only have 5 to comply with the request.
Lovely. Thank you, Mariam, for that. So thank you for all those questions. We had lots of great questions there. I'm afraid that's all the time we've really got for today. So if we didn't get a chance to answer your question, you can check out our FAQs on the SME Web Hub area of our website. That's at www.ico.org.uk/hub. And here you'll find lots of questions on topics from data sharing and security to people's rights and transparency. And you can also get in touch with us directly. We've got a helpline service. So it's 0303 123 113. And we run that service as a helpline for businesses between 9 a.m. to 5 p.m. weekdays. And you can also email. We can deal with emails that you send in to us at ico.casework@ico.org.uk. And you can also use the live chat service that's available on our website. So thank you very much for joining us today, especially when it's been so exceptionally warm. We hope you've enjoyed the conference and found it useful, the whole day, in fact. And I hope you have a really pleasant evening, and I hope you can stay cool in the heat. Thank you very much. Goodbye.